Hi there, this is Melanie Fenwick Thompson from Wait One Legal Minute. Sorry for the delay, we had some technical difficulties, but today I am here. This is the second live conversation, if you will, that I am having. I hope that you all have joined this conversation, shared with your friends, posted on your Facebook, IG, all your social media accounts. Because this is a forum to express my legal opinions, my ideas about legal issues, sometimes even social issues, and for you to ask legal questions, for me to answer them, and if I can't answer them, for you to refer you to a legal source that can help you. So I see right now we don't have very many viewers, so I'll just talk a little bit about what I've done so far. Last week we had Jamie Tare and Jabrina Johnson, and they were on the live IG show that we had. We spoke about legal issues during the Corona season. This is the Corona season. This is an unfortunate time for the world, and everyone individually and in their businesses are forced to make a shift to make it through this season. So we talked about some of the shifts that they've made and that they see in the legal community with their clients and with their businesses, as well as spoke about or discussed how the court closings have affected their clients, what they see the trend or the new trend is, and how that is affecting their clients. We also discussed how the quarantine will affect marriages. Most of us in the legal field who practice domestic law believe that there will be a spike in divorces, unfortunately. Thank you, Kia, for joining, one of my biggest supporters. But we believe, many people in the family law arena believe that there will be a spike in divorces, possibly, unfortunately, temporary protective orders. If you're in an abusive situation, being or in that same situation and not having any kind of retreat from that situation, it may escalate. So we believe that there will be a spike both in divorces and in the number of temporary protective orders that are filed. Also, on that note, courts are hearing restraining orders or temporary protective orders as an essential business. That is a matter that must still be addressed. Even if the courts are closed, they are open for essential matters and matters that need to be immediately addressed by the court. Thank you, Erica, for joining. Another soror love. I appreciate y'all support. Please come with y'all questions so that I can answer them, or again refer you to someone that can. Kenya, thank you for joining. I appreciate y'all so much. This is the first Facebook Live for Wait One Legal Minute, and I am excited. Of course, I'm nervous, but I'm going to give y'all everything I got right now because I think this is important. This is an important forum for us to share our opinions and share our thoughts and questions, and hopefully get some answers. If I'm unable to answer them, to refer you to someone that can. Stephanie, thank you for joining. I appreciate you. What I'm doing right now, just going over the live video that we did last week. I had two guests on my IG Live. That was Jabrina Johnson and Jamie Tare, two of my business partners, and we had a nice exchange. And again, this is just Wait One Legal Minute is an opportunity to share legal information, as well as provide a forum for other colleagues and for litigants to actually ask legal questions. So I'm gonna, Erica Reed, thank you for joining me. I am going to address some legal questions. Let me finish going through what we discussed last week, and that video should still be on IG Live. And if anyone could check and let me know, we can try to repost that if it is not. The other questions we handled were ways to keep your case moving while the courts are closing, and it's not an urgent matter. So of course you always, you want to first have an attorney, and you want to make sure you're having these conversations with your attorneys, but make sure you're pressing your attorney to keep your case moving. There are arbitrators, mandatory arbitrations that you can use. We have one on here right now. People, use these means to resolve your cases. Always going in front of a judge, whether we're in the corona season or not, is not always the best way to handle your family law matters. Try to resolve them, get a good attorney. You cannot control the other party or the other attorney, but try to resolve your family matters outside of court. The last matter that we talked about was Black Women Own the Conversation. This is a show on the OWN network. Oprah Winfrey, I think the first episode may have come out this past summer. I started filming my responses to some of the issues that are touched on, and they were wonderful topics I think we as minority women professionals can relate to. And the one topic we discussed last week was the issue of hair and your hair in this, and trying to be professional and worrying so much about whether or not you should have a perm, whether or not you can wear your locks, whether or not you can wear dreads, and the different ways that you should wear your hair to be professional. And that's something that is really close to home for me. Probably some insecurities that we learned very young, but it was such a I couldn't believe that was something they touched on in Black Women Own the Conversation, and I was so happy that they really exhausted that issue and why it is such an issue for Black women who are professionals, and why that is so much attention that we have to give to that subject. Hi Jabrina, hi Tequila, hi Regina. Thank you so much for joining. And these are some professionals that have now recently joined the conversation. So ask your legal questions. I have one legal question here. It says, I'm actually trying to take out a restraining order with my students. Talking about a restraining order with my students. What evidence do judges look for? And I'm hitting see more. What evidence do judges look for to move from temporary to final protective orders? Well, in Georgia, when you first swear out a protective order, you go in, the victim, the alleged victim goes in and tells the judge, discusses what issues they're having, why they believe a temporary protective order should be granted. At that point, if the judge finds that that person is in fear and has reasonable has reason to be in fear because of the actions of another person, then the court will enter an ex parte order. That means the other person is not present, is not able to present any evidence. The judge only considers entering an order based on what one person says. So an ex parte order will last for a very short time, and then the perpetrator or the other person will have an opportunity, due process, will have an opportunity to present their side of the case. Once they are served and noticed for a hearing, they will have a full hearing, and the judge will determine whether or not they should enter a final, if you will, as you refer to, a final protective order. Protective orders can last anywhere up to a year, and of course this depends on your state, and all states do not work the same. This is in the state of Georgia. I do have a Maryland attorney on here, and if you want to answer the timeline question, please feel free. But in Georgia, you can, after your protective order expires, you can reapply or ask for an extension for your protective order. So even though your protective order may expire, you may ask for it to be extended. Hi there, Wayne. Hello there, Ramona Stewart Jones. Thank y'all for joining. I am taking legal questions, so if you have any, please let me know. I have another one. Someone sent this to me prior to the show. The question is, post-divorce, 5 years and still awaiting the final half of retirement pension payout. The holdup has been due to former spouse unable to produce documentation and all final income numbers for 10-year span prior to 2015. Any resolution on how to proceed? Okay. In general, let me say that if a party is not complying to your final decree or your final order for your divorce or any matter in general, you can file a contempt action. In the contempt action, you will state what was supposed to have been done or what the court ordered to be done, what wasn't done, and why that person is not in compliance with the court's order, and what remedy you seek. I would suggest, and if you send me a question and you say keep it private or not, if you don't speak on it, I will keep your name private. If you text it to the inbox on Wait One Legal Minute, that is a way to keep it private. Obviously, if you post it on this live website, this live chat, then people are going to see who you are. But you can always send your questions on the inbox through the Wait One Legal Minute Facebook, or you can send it to Gmail account, Wait One Legal Minute, and it's the number 1 at gmail.com. So on this question, like I said, you can file a contempt. You should also speak to the attorney that drafted either the settlement agreement or represented you in the previous hearing in your final decree. Make sure that what you understand, the requirements of the final decree, make sure you understand and have a full understanding of what the court order was before filing a contempt. Preferably, thank you about the hair. Preferably, you want the attorney that represented you in your final decree to thank you for putting the email up there, Erica. My sorors are so wonderful. But ideally, you want the attorney that represented you in your divorce to file the contempt. They're familiar with the case, they are familiar with you, they're familiar with the other party, and probably familiar with the attorney if the other party was represented by an attorney. And they can probably just shoot the attorney an email and say, hey, we still don't have this, can you provide this information so that we can move forward with dividing the pension. If not, they can then file a contempt, and you probably will even get attorney's fees as long as they can show that they did try to reach a resolution prior to filing and the other person is actually in contempt. So I hope that answers your question. I'm looking for some more legal questions. So the email again, as my soror put it up on the chat, is waitOneLegalMinute@gmail.com. If you want it private, you can send it on the inbox for Wait One Legal Minute. Or really, I would prefer if you put it on this chat if you don't need it to be private, because trying to navigate multiple means of questions might get a little hectic to me. So while we wait for more questions, and I had a difficult time getting on the computer Facebook Live, so I am literally holding my phone right now, having this chat with you. You are so welcome. Thank you all for joining. So while we wait for more legal questions, what I wanted to talk about is custody and visitation during this state of emergency. Listen, people, I really, every time I hear this, I'm like, wait one legal minute. How are you going to not let your spouse or ex-spouse or baby mama or baby dad, I don't care, not visit with their children? Listen, you have to allow visitation unless a court orders otherwise. I appreciate many of the Georgia courts coming out with orders, getting out in front of this, saying, hey, you have to allow your parent, the non-custodial parent, to exercise visitation. Don't use this, these desperate times to prevent and to alienate your non-custodial parent from exercising visitation. These are scary times. Don't add to the court proceedings and add to the anxiety and the angst by not considering your child's needs. Your children should have a relationship with your non-custodial parents. custodial parents, you should support and encourage that relationship. Don't look for reasons to prevent the other parent, the non-custodial, from exercising visitation. I'm just going to say it. It is petty, and it makes me say, just wait one legal minute. Why? Why? And my clients know, I talk to them. It is what it is. They may not always like it, but I'm going to tell them how it is. You cannot prevent visitation. You have to encourage, you have to foster that relationship between the non-custodial parent and the child. Good parents do that. Obviously, if there are reasons why you are preventing that relationship or preventing that visitation, that's something you need to take up with the court by way of a modification of custody or a modification of visitation. I get it. There are some unique situations. If so, take that up with your lawyer, follow the proper channels, and don't use this desperate time, the state of emergency, as a reason or a basis to prevent or alienate your non-custodial parent or your child's father or mother or whoever. I have another question. What process is in place for victims of domestic violence to apply for waivers if not able to apply filing fees? Well, that is a great question. Some courts do not charge for temporary protective orders. You have to contact the clerk of the court, and many of them are closed right now. So you can go online or contact the clerk or contact an attorney in the county or the state where you are, and they can assist you. The best way is to reach out to the clerk and to find out what their procedures are, what they've put in place during this time. But in general, you don't have to pay a filing fee for a temporary protective order. It is quasi-criminal in most states, which means it is not purely a criminal case or purely a domestic case, hence quasi. And so there are modified rules for temporary protective orders. Let's see, I have another question. If the parent has decided to not proceed with visitations due to current situations, no fault? Absolutely none. Keep a record. Tell them to email you so you have it. Ask them to text you so that you have records. And some parents have. I have clients who have contacted me saying that the non-custodial parent has elected not to visit. They can do that. Especially if one of the parents or the non-custodial parent especially is working at an essential job and is required to still be out in the public and does not want to be a detriment to the child, or doesn't want to inflict the child on anything that they may bring home. I've had those situations too. Well, if the person is deciding that they don't want to exercise the visitation, then that is up to them. I would just ask, and I just like to be real with my clients, don't bring a contempt action against them for not exercising visitation. Let's just be reasonable. Be reasonable. I think that's a great question. I don't think a court will hold a person who is not wanting to exercise visitation in contempt, okay? And what good is it? What good is that if they don't exercise visitation if you file a contempt? And I would just say, just keep a record so that they don't later file something saying you were in contempt or you intentionally withheld visitation, because you never want to be the person that is in contempt of any final decree or any domestic order or any order at all. So I think your questions are great. If anyone has any more questions, I'm going to look on the Gmail account and see if anyone emailed a question. But again, it is best to put your questions here on the chat, or inbox me if you do not want your name shown with your question. But these questions are great. Melanie, I know you had, thank you for joining. I appreciate your support. I know you had a conversation about visitation during the corona season. Melanie is also a family law attorney here in Georgia, and we are on multiple chats between the attorneys, and hopefully resolving and staying ahead of some of these issues. Listen, it is tough in these cases when you don't have a reasonable attorney or a learned attorney on the other end. It makes it very difficult, and it costs our clients more money to litigate against another attorney who is not reasonable or who is not experienced in family law and does not know what the standard is. Having said that, attorneys like Melanie's and myself, who are constantly trying to stay ahead of any changes in the law, as well as temporary changes due to the corona virus. We're spreading the information. We're making sure that we are all learned in what is happening, and we're sharing that information with our clients. So Melanie's is doing something similar to this live chat. She's done a few. Many attorneys are. Get on here, listen to the information we're sharing with you. If it's not for you, share it with someone who you think may need this information. Here is another question. Are visitation centers open during this time for supervised visitation? So let me give some background to this question. Sometimes there are situations where supervised visitation is required because of the conduct of one or both parties during exchanges or in the history of their relationship. In those instances, the court sometimes orders supervised visitation or supervised visitation for the exchange. I just recently had requested and had granted and if you're in Georgia, we asked for Nia's Place for a supervised visitation as a place of exchange, not for the entire visitation, but because it was so much drama around the parents simply exchanging the child for visitation, we had to be creative in finding a resource. And I had already been familiar with Nia's Place through supervised visitation, but we had to confirm, and we researched and reached out to Nia's Place because I've used them in the past, confirm if they just were available for the exchange of visitation. I will contact those places to be sure that they are open. I do not know for sure if they are open during this season, but because many of those places that offer supervised visitation also offer exchange supervised visitation, then I'm guessing they at least would be open for the exchange. Contact the supervised visitation centers that you use and ask them if they are open during the season. They may have limited hours, they may have limited days, because I am guessing that they have limited personnel. So it is best to contact the supervised visitation centers that you use. Contact them directly, and if yours isn't open, ask if they know of a center that is open, because visitation still has to happen. So I'm guessing that either they are open or know of a center. It may not be convenient, but know of a center that is open. If anyone else has any legal questions, these are great questions. I didn't even I've anticipated most of these questions just because if you didn't know, I've been practicing family law since 2004. So although this is a unique time in our society, many of these issues are ongoing in family law. They are not new. They are not unique. So we are familiar with many of the issues that are coming up. It's just a slightly different slant. So I am very familiar with and anticipated most of the questions that I've addressed already. But given the time that we're in, the question like the supervised visitation center being open, I didn't anticipate that, and that's a great question. So great take home. Make sure you get that to your friends or clients who are using supervised visitation centers. And also right now, that's a good segue, just want to talk about good attorneys during this time. I am a good attorney because I use reason. I think outside the box. I don't limit myself to what someone is telling me or what the other side is telling me or what I'm reading. If I believe that there is a way that I can help my client. And many of my wonderful colleagues, if Melanie, since you're still on here, another shout out for you. Many of my wonderful colleagues who I constantly consult with and constantly share information, get information, send information to, we are always pushing each other to think outside the box. So what I want to say is make sure you always have a good attorney that is just not going to stay stuck in the four corners of the law or the document that you have, and that they're going to work hard and think outside the box. This is a time that we're being forced to think outside the box, to get things done in a way that is not as traditional as it has been in family law and other areas of the law. Stephanie Dixon is on. Thank you, Stephanie, for joining. She is a licensed mediator in the state of Georgia, and what she's done with her business, and many mediators are doing, are offering virtual mediation and binding arbitration for attorneys like myself who do use mediation as a means to settle cases. This allows us to keep cases moving. Your case does not have to stop because the courts are closed. That's why it's important to utilize an attorney with a good reputation and can think outside the box, and has the technology and has the staff to manage your case under any circumstances. Okay, so in the case of my firm, Fenwick Thompson and Associates, we have this virtual thing on lock. We have been doing virtual legal services since November 1, 2019, because we bought a building, it's not done, we're working hard to finish it, but in the meantime, my entire staff had to telecommute since November 2019. Now listen, I don't mean to offend anyone, but I believe God is in control, and everything happens for a reason. So when everyone was just in a frenzy trying to convert their firm and their employees to telecommuting, our firm already had it on lock. We've been doing this since November. We can continue to provide legal services. We have continued through this unfortunate season uninterrupted. We conduct our phone consultations through Zoom. We have been for years now, but have gone 100% through, since November 1, 2019, and we will continue to provide our legal services, professional efficiency, legal services uninterrupted. Thank you. I think I have another question here. Kenneth, thank you so much for joining, y'all. There's somebody from middle school who is doing wonderful things in film. I think you are a grip man. There are people out there to do everything to make this world go around, and I think you were on one show that I really like. Kenneth, I think I must have reached out to you when you posted something, and I can't remember the show, and I don't want to misspeak, so I won't. But has your job or industry been affected at all? It seems like people are watching so much TV and many shows, so I would think that you are continuing to work uninterrupted. But if you are still on and can respond to that, I'm just interested. I have a few friends in the production arena and the entertainment industry, and I wonder how this season is affecting us. Tabby, thanks for logging on, friend. How are you? So let me get back to this question. I had a little diversion there. Each state varies, however. Is there a legal age when the child can advocate for himself to stay with one parent, no longer continue 223 schedule, and stay with one parent, visits to other parent whenever instead due to school, sports, schedule, etc.? Such a great question. Let me start and let me just break it down. Can a child advocate for themselves, and is there a legal age when they can't? Okay. Many states have a guardian ad litem that advocate or represent the best interests of the child. Okay. The guardian ad litem is appointed by the court to represent the child so that the child has a voice. The child and the guardian ad litem will meet together. The child will tell the guardian ad litem what their desires are, why. The guardian ad litem in most cases will conduct a full investigation. So they will contact collateral sources and information that the child gave to them, investigate both homes of the parent or the guardian or the legal custodians, talk to teachers, talk to any collateral sources that are provided to them in their interview with the child or with the parties, and will try and determine what is in the best interest of the child. In general, if a child, let me say in the state of Georgia, and I'm so sorry, Kenya, I know you're not in Georgia, but many states have similar laws. And if there's anyone online who is from Maryland and is a licensed attorney, I don't see Sora. I'm trying to scroll through here. So if there's any licensed attorney in Maryland who is practicing domestic law, if you want to chime in, please do. But in general, here in the state of Georgia, at the age of 11, the court will take a child's desires into consideration, and at 14 will follow the child's desires unless it finds that the election of the child is detrimental to the child's best interest. So of course there's some caveats, but in general those two important ages here in Georgia are 11 and 14. At 14, the court really does consider the child's desires and will grant the child's desires unless the other parent or the other litigant can demonstrate why the election is not in the child's best interest. Really important. I had a case where the two older children, there were 3 girls involved, the 2 older children wanted to go with the non-custodial parent, and they were 14 and 16. I demonstrated to the court why the election was detrimental to the girls' best interest, because there was parental alienation and influence which drove the election. Okay, so you want to be careful if you are the custodial parent and your child does not want to continue visitation and you want to modify that visitation. Of course, I always start with just talking with the other parent, explaining what the child desires. Sometimes the child has spoken or should speak with if they're of age, if they're 14, and they're in high school, then the child's priorities change. And the parents have to, again, be reasonable. Be reasonable. Remember when you were 14 years old and what your priorities were. And in high school, extracurricular activities and sports become more and more important. But again, you always want to encourage the relationship. So the parents need to work together. But if the child is saying that they want to change the schedule and they understand that impact and the parents can respect that, then you should honor that. And if not, and if you think it's in the best interest of your child, you need to file a modification of visitation or a modification of parenting time, depending on what your original order, was entered, and what you're trying to change. I'm going to scroll down. Hello, Tabby. Hello, Kenya, New Jersey. Kenya Brown, 14 years old. Okay, so Kenya in New Jersey is stating that who asked the original question, stating that are you stating that the child is 14 years old, or in New Jersey, the age of election is 14 years old? I'm not sure. But yeah, most states, Georgia has the 11-year-old as the child being able to express their desires, and the court taking it into consideration. And that is young. And that's why it is only taking it into consideration. But yes, okay, she's saying that her daughter or her child is 14 years old. Yes. And so many states, the age where the court will accept the election, and I'm referring it to as an election because it's an election of a minor or a selection of a minor, and of course that the name of that affidavit that the child will sign will change, but the child will actually sign an affidavit saying that they want to live with one parent over the other. When that happens, then you file that with your modification. And again, if you can resolve all this outside of court and just do a settlement agreement, that's the best way. But if you can't, and you have to file a modification, then your child will have to, if they are willing, to sign an affidavit, which is the selection of a minor, sign it, have it notarized, and that'll be filed with your pleadings. I just don't like putting children in the litigation. But if that is necessary for your particular circumstances, then it has to be done. Any more questions? These are great questions. I want to thank all of you all for joining and asking questions. This was so much fun for me. And like I said, these are live conversations that I want to have just to be able to, for people to get legal questions answered, for me to answer what I can, refer you to resources that may be helpful to you, and just provide a platform for the exchange of legal information or social issues or whatever you would like to discuss. We went over. I expected this to go until 11:30, but we started a little late. So I thank you all for joining. Please share my Facebook page, Wait One Legal Minute, with your friends, family. Subscribe, ask them to subscribe and to like. I appreciate you all, and you'll get a notification if you have followed Wait One Legal Minute. You'll get a notification as to when the next live will go forward. I am guessing it'll be sometime later on this week. I did not expect to launch the show this soon, but in light of this season and being stuck in the home, I launched the show much sooner than I anticipated. So thank you all for joining, and look out for the next notification for Wait One Legal Minute to go live. And go ahead and still inbox my Facebook to share or ask or comment with any legal questions, and I will be sure to respond to them at the next live show. Thank you. Have a good one. Y'all stay safe. Stay home. Stay home.